Hi, I'm Alexis Moore, alexismoore.com. I'm a risk management expert and a consumer advocate, and I'm here to give you some tips on debt collection practices that you need to be aware of as a consumer. First off, if you're receiving phone calls and they're all time of the day and night, that's the first thing you need to say to yourself is, okay, if it seems like it's harassment to you, it more than likely is, so you need to figure out whether what your next step will be. Going to NACA.net, which is the National Association of Consumer Advocates. So again, it's NACA, NACA.net, and there's a list of attorneys there by state and also advocates that are there to help you, that specialize in consumer advocacy and protecting consumers from credit collector harassment and also inaccurate credit reporting. So once again, the minute the phone begins to ring and you say to yourself, wow, I'm getting multiple calls, that should be a light goes off and you say to yourself, you are dealing with an agency that's not abiding by the law, and you should immediately reach out for help from a legal side, and that would be a lawyer then that's a part of this NACA network, because NACA attorneys, it's a nonprofit agency, but the good thing is they all specialize in credit collection and consumer advocacy in this particular area of law. So that has to do with credit and collections. Next point I can make, debts. If you have a debt and it is a legitimate debt or it's not, by law you are given 30 days to dispute any portion of the debt. If you do not receive written notification advising you, the consumer, that you have 30 days to dispute the validity of the debt, you also are in a situation where you're being violated, and you definitely need to proceed in documenting this by keeping the letter. Go ahead and visit NACA.net again, or you can visit my site, alexismoore.com, and find out how you can write to dispute the debt, certified letter explaining that you either owe it or you don't, and begin from there to document every single communication you receive by phone, by letter. If there's a note on your door, if they post on a Facebook wall or tweet you, or anything that you know to be a communication from a debt collector or a representative thereof, you do have rights and protections. If you're receiving any communication in writing from a debt collector, that means email, it means written letter, any of that, fax, all of these communications in writing, they must have what we call a debtor Miranda warning or notice. These will vary in the wording, however, the wording will state something to this effect. This is an attempt to collect a debt, and any information obtained will be utilized for that purpose. If you don't see in that letter, whether, again, I'm going to go back, fax, email, a tweet, anything, if someone's sending you anything in writing that's not saying their intent and giving you that notification at the bottom of this letter, what we call a Miranda notice, you're definitely dealing with an agent or a company that's not abiding by the law. So look again to see, are they giving you that notice saying, as the consumer, you are they are attempting a debt or to collect a debt against you, and whether or not that notification is at the bottom, because that's very important for you to protect your rights. And that notification allows you, the consumer, the opportunity to dispute the debt and to prohibit them from credit reporting you or contacting you for 30 days while you determine whether or not the debt is indeed valid. Next step, if you're in a situation where you're being contacted at work, we are in the industry, 9 times out of 10, they are going to try to find out where you work, and they're going to find that information easily. So you may be contacted at work, your coworkers may be contacted. Rather than standing and saying, oh boy, I'm just going to try to ignore this or sweeping it under the rug, address it head on. They should not be calling you at work if they're putting you in jeopardizing your career or your position at the company. So what you need to do then is what we call a cease and desist letter. Cease and desist. And it's sent certified letter to the company that's calling you. So be sure when they do call, say, hello, your name, I'd like to know who I'm speaking with, what is your address, and send it out, and also fax number, I advise. Send them out a certified letter noticing then to what we call cease and desist, and the letter just need to say your name and the phone numbers that they've been calling you at, and that they're not to contact you at work or at your home, and they can no longer contact you in writing or on the telephone. So again, it's a cease and desist letter. It's very, very important, especially for those of us that are suffering now in this economy. You may or you may not owe the debt, But regardless, you have a right to work in peace and a right to be at your home and to enjoy your home without the phone ringing off the hook and receiving multiple letters over and over again. So cease and desist, I think that's the biggest takeaway from this entire process. If they violate the cease and desist once the certified letter goes out, you as the consumer have rights. Again, seek out your lawyers that are affiliated with this NACA, National Association of Consumer Advocates, NACA.net. Document the fact that you sent out a certified letter by making a copy of that letter prior to sending it and ensuring that you protect yourself. No one has the right to harass you or to intimidate you or humiliate you or put you in jeopardy at your job just to collect a debt. It's not appropriate, and it's also against the law.